On Blackboard, I'll post a PDF of what the court system looks like in Texas. It's pretty similar to the map that Judge Garza showed y'all in class on Monday. But one of the things to keep in mind is that there are lots of different trial courts in Texas, and that many of their cases are determined by specific issues and the amount of money involved. And this is something that Judge Garza talked a little bit about with y'all on Monday, but I just want to make sure that we are all on the same page with regard to what he's talking about. So at the lowest level are the JP and municipal courts. And so every county in Texas has JP courts, and they handle what are called Class C misdemeanors. For example, theft of items worth less than $10 or disorderly conduct. In these cases, jail time's not a possibility, and people pay a fine. In some cases, the JP courts can also issue search warrants or issue arrest warrants if the JP, the Justice of the Peace, actually has a law license. The municipal courts, for example, they have original jurisdiction for cases originating inside city limits. So, for example, in Victoria, there's the city of Victoria, and then there's the county. If you are within the city limits of Victoria, you would go to municipal court. If you are outside of the city limits, and you need to kind of look for the signs on the roads indicating whether you're in the city or not, if you're outside of the city limits, your case would be handled in JP court if we're talking about a Class C misdemeanor. So, for example, if you're under the age of 18 and you have tobacco, or if you possess drug paraphernalia, for example, an empty bong. And so municipal courts also deal with municipal ordinances, so that deals with sidewalks and grass. So, for example, if you have a neighbor who doesn't cut their lawn or fails to trim their trees, the city can come out and say that you need to do this, and if you don't, the city can actually force you to do this. Most municipal courts are not courts of record, so if you choose to appeal, they would go to the county courts and it would start completely new, and this does increase the expense of conducting cases. And so, in addition to the JP and municipal courts, there are 254 county courts across the state of Texas. And again, as Judge Garza talked about, there's difference between the county courts, which are constitutional, which means the state constitution requires that every county have one of these courts, and then county courts at law, which are statutory, which means they are created by the legislature. And so the county courts can handle both administrative functions as well as legal functions. Primarily in Victoria County, the county courts are administrative. They do record keeping, things along those lines, and they don't hear much in the way of cases. That will differ in some of the rural counties. Most of the criminal and civil matters will be handled by the county courts at law, and these deal with Class A and Class B misdemeanors. So a Class A misdemeanor is burglary or theft of property worth between $500 and $1,500, or a Class B, which is DWI, or possession up to 4 ounces of marijuana. With a Class A misdemeanor, if you're convicted, you can actually pay a fine of up to $4,000 and spend a year in county lockup. A Class B conviction, the fine is limited to $2,000 and jail time of no more than 180 days. So these county courts and the county courts at law handle appeals from the JP and municipal courts, and in some of the larger counties, the state has actually created what are called statutory probate courts, which are responsible for probate matters, things like wills, guardianship, mental health commitments. If you're outside of one of the big counties, Harris, Bear, Travis, and so forth, then probate matters are shared with the constitutional county courts or the county courts at law, depending on what decisions the state legislature has made. The most important thing from our purpose is that if you are charged with a felony, then those cases are heard in district courts. And there are almost 460 district courts in Texas, and every county in Texas must be served by at least one district court. And as Judge Garza talked about on Monday, there are 4 district courts that affect Victoria County. Some of the judges travel about into Goliad and Refugio, and other counties. So you've got some variation there. And what's really important here is that if you are charged with a felony, the district courts are the court of original jurisdiction. In addition to handling criminal matters, the district courts are also responsible for civil litigation such as contested elections, divorces, contests over land, or when money or damages exceed more than $200 in a case. In fact, family cases actually comprise the largest share of all cases heard in district courts, 38%, which is slightly more than criminal cases. Given the large backload of cases, many of the civil suits are settled through negotiation or arbitration to avoid lengthy delays. In a in district court, the judge presides over the trial, but it's a 12-person jury that has the responsibility for determining guilt or innocence. The judge will give instructions. The judge will make rulings throughout the course of the trial. But at the end of the day, it's a jury of 12, and we'll talk more about jury selection in the future. It's a decision of 12 people to make that decision, and so it's important to kind of keep that in mind. And all of you have perhaps at some point gotten a summons for jury selection, and so jury selection is an important part of the process where the lawyers in a case help put together a jury pool. So it's not completely random, but rather it's a random selection of people who are put together in the jury pool. And then if you're ever part of jury selection, you'll come to a kind of a central collection area. And then people will announce you, and you'll go off to different areas. And then you'll fill out some paperwork. Lawyers will ask you questions. And then some people from the jury pool will be struck. Other people will be kept. And so eventually the process will get whittled down from maybe 50 or 60 people in one courtroom to 12. And they may include a few alternates. And so it's the jury that has the ultimate responsibility. Should you not like the outcome in district court, then you have the right to appeal. And there are the Texas Courts of Appeals. They are an intermediate court of appeals, and they serve different geographic regions across the state, and they possess appellate jurisdiction in both civil and criminal cases, which means they review the legal issues. So they don't hear a case again. They just simply review the legal issues. Was the counsel, the lawyer for one of the sides effective? Was evidence allowed to be introduced? Did the judge make a ruling that was inconsistent with existing law? And so Figure 2 in Chapter 7 shows you the location of each of the courts. The number of judges on each court varies based on the laws created by the legislature. So the size of the courts ranges from 3 judges to 13 judges. The Court of Appeals decides cases in randomly assigned 3-judge panels, and they have 3 options when deciding a case. They can affirm a decision, basically saying that the decision in district court was right. They can reverse the decision, say that it was wrong, or they can modify it and send it back down to district court and say this is mostly right, but there's one point that's wrong. There's no discretion in these courts of appeals, so they have to hear every single case from the lower of courts, but it is the court of last resort for cases originating in JP or municipal courts. And dividing the appellate courts into 2 separate levels, and we'll talk about that in a minute, represents, again, that distrust of centralized authority. Texas is one of 2 states that has 2 Supreme Courts. Oklahoma is the other, by the way, for those of you interested in trivia. So we have 2 Supreme Courts that handle final appellate jurisdiction. Out of all the cases tried in Texas every year, only about 4% or so reach either the Court of Criminal Appeals or the Texas Supreme Court. The drafters of the 1876 Constitution decided that 2 Supreme Courts were needed because the Texas Supreme Court was overburdened with cases, and it would allow each court to specialize in specific areas in the hope that justice would be dispensed more quickly. Since 1974, there have been 6 efforts to merge the courts, and every single effort has failed. There are 9 members of the Court of Criminal Appeals, and it has discretion over which cases it chooses to hear on appeal from the Texas Courts of Appeals. So the Court of Criminal Appeals handles criminal matters, and they get to choose. They have discretion. So you appeal your case, and they can decide, yes, this is worth hearing, or no, it's not worth hearing. And if 4 judges out of 9 want to hear a case, it's scheduled for review. The only exception to this are capital punishment cases, which are automatically appealed from district court to the Court of Criminal Appeals. It actually skips the Texas Court of Appeals. And then habeas corpus cases, which Judge Garza talked about, if you get locked up and you're not charged with a crime, your attorney can file a writ of habeas corpus, which means to produce the body, and the state has to make a decision about charging you with a particular crime. They just can't throw you in jail for no reason whatsoever. The Texas Supreme Court is also composed of 9 justices, and it has discretion over all civil and juvenile cases that are appealed from the Texas Court of Appeals. And again, if 4 judges want to hear a case, it's scheduled for review. Besides these civil cases, as Judge Garza talked about, the Texas Supreme Court has administrative responsibilities for the legal profession in the state of Texas. What does that mean? It approves law schools in the state of Texas, so you can't just create a law school. It has to be approved by the Supreme Court, and it appoints the Board of Legal Examiners, which is responsible for administering the bar exam, the test that lawyers have to take in order to be certified to practice in the state of Texas. From time to time, these Supreme Courts play a very important policy-making role. Perhaps the most notable decision was in 1977, where the Texas Supreme Court in Edgewood v. Kirby ruled that the big differences between rich and poor schools were unacceptable and they must be corrected. So pretty much now for the last 40 years, the state of Texas has been involved in trying to figure out how do you properly balance resources between rich and poor schools to make sure that kids all across the state of Texas receive a quality public education, however you want to define quality. Generally speaking, these are the courts of last resort in Texas unless an appellant, the person who is appealing the decision, can find an issue that violates some aspect of the United States Constitution. If that were to happen, then that person can seek review by the United States Supreme Court. For example, in Lawrence v. Texas, this was a Harris County case, the Supreme Court struck down, the United States Supreme Court struck down the state sodomy laws that criminalized homosexual activity as a violation of the Due Process Clause of the 14th Amendment. So the state courts had upheld the laws, and then the United States Supreme Court overturned them. And, you're kind of seeing some of that with voting rights and other things because it violates equal protection. So, generally speaking, the Court of Criminal Appeals, Texas Supreme Court, this is the end of the line unless you can find a federal issue or something to do with the United States Constitution.